the Digital Personal Data Protection Act 2023. It was recently passed by both the houses of parliament and became a law after receiving president assent on 11th of August 2023. So it's one of the first seminars on the topic, I would say, where as we are now reading the law, as everybody is now reading the India's first data protection or data privacy regulation. So it's a landmark legislation, I would say, since it's the first one in India, much awaited for many years. Earlier, it was called a PDP bill, and now it has become a DPDP Act, Digital Personal Data Protection Act of 2023. Now, the DPDP Act aims to protect the privacy of individuals in this digital age. It defines for the first time what is personal data, how can that be used, to identify an individual, which organizations can collect, how they can collect, what is the process, what are the consent, how to obtain consent, etc., etc. Now, Dr. Limaye, again continuing with you, could you give at a very high level a snapshot of the act, just an overview? What is the heart of the whole act as such?
So, heart of the whole act is basically the preface or the intention with which this particular act was enacted. So, after Justice Puttaswamy judgment, it was thought by each and every industry professional and individual that only right to privacy will be protected under this particular act. But our lawmakers have gone one step ahead, and the preface now reads as an act to provide for processing of digital personal data in a manner that recognizes both the right to privacy of individual, that is their right to protect personal data, and need to process such personal data for lawful purposes. So initially, the basic heart of act is now processing is being legalized by this particular act itself, because everybody's data will be required to be processed is a new need of the industry, and to legalize that particular data processing and simultaneously protect fundamental rights of the citizen. So it is a mix of fundamental right protection as well as protection of corporate right of processing of data. So heart of this particular act, according to me, is the introduction of this particular act. Then there are very unique features. If we compare the similar or parallel laws available in GDPR or other countries, here Indian lawmakers have given very better position to data whose data is being compromised. They are referred as data principal. And if you go to other laws, they are referred to as data subjects. When we speak about subject, it is somewhat inferior complex is there. When it is principal, we are the main person whom or around that particular data principal, entire act will be revolving. And the concept used in India is data fiduciary. So whoever is processing our data or capturing our data will be holding that particular data in a fiduciary capacity. There will be some responsibilities, some duties, some liabilities cast on that particular fiduciary. So this comparison or this use of nomenclature, that is the data principal and data fiduciary, itself suggests the way by which Indian DPDP will be dealt with. So customer or data principal is at the topmost level, and protection of his personal data is the heart or essence of this particular data protection act. So the data principal has been given some rights. So separate chapter is dedicated. Then data fiduciaries have been given certain rights for processing of data. Then consent is one of the most essential feature of this particular act. So broadly, what will happen or what is the essence of this particular act is, whether or whichever organization will be collecting anybody's data, that organization will be now required to first give notice to each and every data principal and see the logic or the thinking which has gone into making of this particular act. these notice would be required to given in all Schedule 8 languages. So whatever languages are prescribed under Indian Constitution, data principals will have that particular right to get that particular version in his or her own mother tongue. So everybody, the broad feature is everybody will be understanding what is the essence of that particular notice, and after that particular notice, every data principal will give consent to data fiduciary, and he will be knowing to which data he has given his consent. So he will be provided a list of say ticks in that particular notice that we are fetching these your personal or sensitive data. If you agree, then you will have to give this particular consent. So there will not be any previous like agreements, either accept entire thing or you won't get the service. So there are various enormous good features in this particular DPDP. So broadly, it revolves around data principle, his rights. Another thing is his duty is also held responsible. So there are various duties cast on data principle. As a student of law, we always talk about fundamental rights and fundamental duties. Now, Indian Constitution has these fundamental duties. But if duties are not followed, then there are no punishments for non-following of duties. But here in DPDP, if you fail to follow your duty, or means data principal fails to follow their duty, then they will be penalized. So this is another unique concept which is added in this particular DPDP. So according to me, sum up, DPDP Act for the benefit of data principals as well as data fiduciary. Data principal, his rights are recognized. I should say her because there was another new approach in this particular act. The act always talks about she. So it has changed the general bias from he to she. So everywhere you will find she, her pronounced in that particular act. So her rights, data principals' rights, their responsibilities, their duties, and the scenario under which data can be captured by data fiduciaries and what would be their responsibilities, their role. Broadly, the act revolves around these main things. Other things are procedural part like data protection board, penalties, etc. But mainly it will clarify what are the rights of data principal, what are his duties, and what are the rights of data fiduciary, and in which circumstances they can process the data. This is
Awesome.
say Broadway or
Yeah,
high profile overview.
very nicely summed up, I think, as an overview of the act. And also very nice observation, which I also noticed while reading the act, that he has been substituted with she, which is a welcome step, towards removing the gender bias as well. So, but yes, of course, it says she includes he. So, of course, it applies to everyone, not just the women. Okay, on the other note, now, Samir, I think Dr. Limaye has brought out three very, very important terms called data principle, data fiduciary, and consent. I think which is the heart of or nucleus of the whole act. Data principle being people like us, be it employees or customers or vendors or people whose data is at stake. As he said in GDPR, it is called a data subject, but now it is data principle. Data fiduciary, which would mean people who collect that data. It could be companies, etc. And then third is the consent. That okay, what kind of consent is required before the data could be collected.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.